Hello, welcome to this video on insanity. Now, insanity is a capacity defense in criminal law, so we're going to focus on this and other capacity defenses in other videos. The aims of this one are to outline when the defense can be used and what is the outcome of a successful defense, to be able to explain the key elements of the defense of insanity, to explain the key cases supporting these elements, and as ever, you should be able then to go and apply these to problem questions. So our starting point is there are a number of procedural rules. The defendant is presumed sane in any case, but the prosecution, defence or judge can actually raise insanity. But if the defendant raises the defence, then the burden of proof is on the defendant to actually prove this. But the judge can also decide if a defendant is unfit to plead through insanity. So the rules if we raise insanity as a defence are drawn from Norton's case in 1843. Now here the defendant thought he was being persecuted by the government and he tried to kill Sir Robert Peel, but instead got his secretary. Now he was not guilty of murder but by way of insanity. Now there was public outcry at this decision which forced the House of Lords to clarify the law, which meant the Norton rules were born. And so these Norton rules essentially come up with a definition of insanity. So the definition is, on a balance of probabilities, the defence must prove that at the time of the offence, the defendant was labouring under such a defect of reason from a disease of the mind as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. So what we can see in the underlined text there is these are the elements. So we break these down. We need to analyse what each of these things mean, and we've got a defence of insanity. So we've broken this down. We've got a defendant must have been suffering from a defect of reason. So we're going to look at what a defect of reason is first. It must result from a disease of the mind, and we'll look at that context and how that's changed from just the mind. And of course, those two options at the end, the defendant was caused the defendant not to know the nature and quality of his act, so he didn't know what he was doing, or not know what he was doing was wrong. And we're going to see how case law has illustrated all of these points. So we're going to begin then with this defect of reason. The defendant must be suffering from a defect of reason. Now this phrase defect of reason implies that the defendant's powers of reasoning must be impaired, as opposed to a failure by the defendant to actually use those powers. So what it means is the defendant is unable to reason rather than being able to, but not doing so. So it doesn't matter if the defect is temporary or permanent, it just has to be present at the time of the commission of the crime. So looking at Clark, this obviously the case facts here are quite lengthy, but you can just pause and read through if you want. But in essence, Miss Clark was accused of shoplifting, and he argued she'd been acting absent-mindedly because she was suffering from depression. Now, the end result in the Court of Appeal here was her behaviour fell very far short of showing she suffered from a defect of reason. The court ruled the evidence meant that she was denying mens rea rather than raising a defence of insanity. Now, quite simply, she was able to reason but didn't do so. That is not going to be enough for insanity. So the second element we look at is the disease of the mind. So we need to understand what a disease of the mind is and how that's changed and how cases have addressed this issue of disease of the mind since the Norton rules were introduced. So the first thing to remember is disease of the mind is a legal term, not a medical term. So we don't need any medical evidence as such in the same way as we do for diminished responsibility. But it could be any disease of the mind or a disease of the body which either affects the brain or the mind. Now, an irresistible impulse is not enough to substantiate insanity, though it may be used to support diminished responsibility, for example in Bern. We know disease of the mind also doesn't cover absent-mindedness, as we dealt with in Clark in a previous element. And it covers states of mind which doctors would be highly unlikely to characterise as disease of the mind, but covers any internal disorder which results in violence and is likely to recur. So we look at Kemp. This involved hardening of the arteries, which meant that there was congestion of blood to the brain. Now the defendant was suffering that in this case, and through a temporary loss of consciousness he attacked somebody. And he admitted he was suffering from a defect of reason, but he argued it wasn't a disease of the mind. Now in this case, the defendant did not want the defence of insanity. But in this case, the disease of the mind was defined as a temporary or permanent, curable or incurable defect in the ordinary mental faculties of reason, memory, and understanding. So there's enough here. If a physical disease can affect the mind, it can support insanity. In Sullivan, the disease here was epilepsy. Now, Patrick Sullivan, the defendant, had been known to have fits and to show aggressiveness to anybody coming to his aid. Now, one day he was sitting in a neighbour's flat with a friend of his, and the next thing he remembered, he was standing by a window and Mr. Payne was on the floor, injured. Sullivan was charged with inflicting GBH, and the judge ruled epilepsy amounted to a disease of the mind within the Norton rules, and in order to avoid hospitalisation, Sullivan pleaded guilty. Now, his appeal to the House of Lords, where the internal-external divide was strictly applied, was rejected. This was a physical disease which affected the mind and again could support a defence of insanity. Now, in this case, again, it just illustrates the point, even though the defendant didn't want to use this defence. Now, in Hennessy, this involves diabetes, again, a physical disease which can affect the mind. In this case, the appellant had stolen a car and was stopped by the police while driving it. He was taken to the police station and at first felt well, but was later taken to hospital because he was unwell. Now, he was a diabetic and was required to take 2 insulin doses per day. Now, he'd not been taking his insulin and he was in an emotional state that his wife had just left him. Now, the appellant had no recollection of taking the car, but the appellant raised the defence of automatism. However, the trial judge ruled the appropriate defence would be insanity. Now, if you come to the automatism video first, you'll understand that injection is an external cause. If you inject insulin, that would be automatism. But in this case, it's the disease from the internal cause, which is, of course, makes it insanity instead. So you're going to look at that when you do the automatism video. Another case, so Burgess, involves sleepwalking. Now, in this case, Barry Burgess and Katrina Curtis were in Burgess's flat watching videos. They both dozed off, and during the night he attacked her while she slept, hitting her with a wine bottle and the video recorder, and then grasped her by the throat. Now, she suffered cuts to the head, and Burgess was charged with a Section 18 offence. Now, he pleaded automatism on the basis that he'd been sleepwalking. The trial judge said the appropriate defence on the fact was insanity, and he was found not guilty by reason of insanity and was ordered to be detained in a secure hospital. That's a special verdict, which we'll come to later on. Now, his appeal was dismissed on the grounds that sleepwalking was caused by an internal factor, the sleep disorder, and the judge had given the correct direction. So again, a condition which can affect the mind was sufficient here. So we do need to be careful in any problem question. The key difference between automatism and insanity is one arises from the internal factor, the disease of the mind, that's insanity. But where there are external factors, we'd need to use automatism instead. Now, for automatism, if the defendant doesn't know what he or she's doing because of external factors, then that's a starting point for automatism. It can't be insanity because it's not a disease of the mind, nor is it a physical condition which can affect the mind. So, Quick is another diabetes case. Now, we need to contrast this with Hennessy, as we discussed earlier in the video. Now, Quick basically was not insane because in this case the insulin had made him act in a way. So again, it was diabetes, and the cause of his automatic state when he committed his crime was not the diabetes, it was the treatment, the insulin, which was injected as a result of the diabetes. So because this was not an external factor, this was not insanity. We can also look to Coley. Now, the defendant here, a regular user of cannabis, attacked a neighbour and her partner with a knife. Now, when arrested, he was calling out for his mother and said he'd blacked out. Now, there was medical evidence to suggest that cannabis used could have caused a psychotic episode, but his conviction was upheld and therefore the defence of insanity was not successful, as this was caused by the intoxication, so the cannabis, and is therefore not an internal cause. Again, we've got an idea of external causes when people may act what you might consider to be insane, but it's not insanity because it's not an internal factor or internal cause or a disease of the mind. So we've got Lippmann. Now, Lippmann you'll come across also when you do intoxication, But here the defendant was on an LSD trip and thought he was fighting snakes at the centre of the earth. Now in fact, he was stuffing bed sheets down his girlfriend's throat and killed her. Now he couldn't use the defence of insanity for the offence because he was intoxicated from the LSD, and so therefore, again, was not a disease of the mind or a physical disease which affected the mind. So once we've established a defendant is suffering from a defect of reason, i.e. they are unable to reason, rather than being able to do so and failing to do so, we then establish a second element, and this is a disease of the mind. And as we know, it's got to be an internal factor, and it's got to be a disease of the mind or a physical disease which affects the body or mind. Once them two are established, we can do either of the next two things. So those that disease the mind, the defect of reason, causes the defendant either to not know the nature and quality of their act, so they don't know what they're doing, or they don't know what he was doing was wrong. So we're going to explore each of these two elements, and it is an either or situation. Only one is necessary to prove this defense. So we'll deal with that first one, did not know the nature or quality of the act. So for this element, the defendant must not be aware of nor appreciate what he was actually doing, the circumstances of it or the consequence of the act, either because of he's in a state of unconsciousness or he's conscious but he doesn't understand what he's doing. Now unconscious doesn't just mean asleep, for those who might be confused by that. It is simply they're unable to be aware of what's going on. So again, we've looked at Kemp, which arteriosclerosis we dealt with earlier on. Now the blocked arteries here meant that the defendant was in a temporary state of unconsciousness when he attacked his wife with a hammer, and he was found guilty, not guilty by reason of insanity, and the Court of Appeal upheld this, stating the law was not concerned with the brain but with the mind. His mental faculties and reasoning were affected by his condition, so he came into the definition of insanity. In Codier's case, in this case the appeal court made it clear that the defendant will not be able to rely upon such a contention just because it feels what he's not doing is morally wrong. Now for example, we've got the man who feels he's morally justified in killing prostitutes, like for example Peter Sutcliffe, would not come under the rules if he was able to appreciate that he was breaking the law. So if you know you're doing wrong, then of course you cannot satisfy this element. In Oy, the defendant here was acting irrationally in a cafe, and he threw crockery at the police when they came. Now he continued acting oddly, culminating in punching a police officer and breaking a jaw. Now his defence was that he was having a psychotic episode and thought the police were agents of evil spirits, which was supported by medical evidence. On appeal, the verdict of not guilty by reason of insanity substituted the conviction of ABH, so the defence was successful. Now in Windle, the defendant, who was a 40-year-old man said to be of weak character, was married to a much older woman who was believed to be insane. Now she often spoke of suicide, and a workmate of the defendant, irritated by Windle's constant complaints about his unhappy home life, suggested giving her a dozen aspirins. The defendant instead gave her 100. Now a defence doctor believed that the accused was suffering from folie à deux, which is a form of communicated insanity, but both sets of doctors agreed that Windle knew when he was performing a wrongful act. When he was caught also, when the police spoke to him, he said, "I suppose they'll hang me for this." So that was his undoing. By saying that, he knew what he was doing was wrong, and so he couldn't use the defence. In Johnson, the defendant stabbed his neighbour after barging in his home. He was found to have paranoid schizophrenia, and psychiatrists on trial stated that he knew the nature and quality of the act and that it was legally wrong. So the Court of Appeal upheld the conviction for wounding with intent due to following Windle as a precedent. So he knew what he was doing was legally wrong, therefore that's enough to secure a conviction rather than the successful defence of insanity. So of course, a little bit of overlap here. The defendant doesn't know the defendant act was wrong. So we've got this idea that he either doesn't know what he's doing or he doesn't know what he's doing was wrong. Now wrong is just taken to mean in law, not morally wrong, but do they know it's wrong in law? Do they know it's against the criminal law in this case? So therefore, if the defendant knew he was acting contrary to the law but was suffering from a disease of the mind, he wouldn't be able to use a defence. So again, we got Windle, and he knew, as we said, I suppose they'll hang me for this when caught by the police. and of course by saying that he knew what he was doing was wrong, and so therefore he couldn't use the defence. Now, if all of these elements are satisfied, then what we have is a special verdict of not guilty by reason of insanity. So it is a defence, but has a special verdict. And what this does is leave the defendant under the control of the court, and the sentencing powers are set out in Section 3 of the Criminal Procedure, Insanity and Unfitness to Plead Act 1991. So where the defence for the offence to which the finding relates is fixed by law, so for example murder, the court has to make a hospital order restricting discharge without limitation of time. So they're in hospital. Now, in any other case, the court may make a hospital order and an order restricting discharge either for a limited or unlimited period of time, or in appropriate circumstances for sort of lower level crimes, a guardianship order might be relevant, a supervision and treatment order, or even an order for absolute discharge. So there is a scope there for the judge to be more flexible depending on the crime. Now, a quick note, a hospital order then is an order that the defendant be admitted to and detained in the hospital in order to receive treatment for a mental disorder. Such an order may be used upon proper medical evidence and only after the conviction for an imprisonable offence. So what this means is we're not going to be using insanity as a defence for those lower level crimes. Of course, we only need that if we got all of the elements. So just to recap here, the defendant needs to be suffering from a defect of reason, which is a result from a disease of the mind, and it either caused the defendant to not know the nature and quality of his act, or not know what he was doing was wrong. Okay, so this rounds up the video on insanity. So it's a capacity defense. We're also defense videos on intoxication and the alternative, if you like, to this, and that is automatism. So you should watch those two. They will all possibly be on your exam. So good luck and thanks for watching.